Nobody in that courtroom had ever seen a defendant take notes during his own trial. Not in 30 years of criminal proceedings in New York County. But Ellsworth, Bumpy Johnson, sat at the defense table with a yellow legal pad and a sharp pencil, writing something down every time the prosecutor spoke. His lawyer leaned over twice and asked him to stop. Bumpy shook his head both times. What he was writing was not a defense. It was a list. To understand what was on that list, you need to go back 14 months. To the morning everything was set in motion, not by Bumpy Johnson, but by the men who believed they had finally found a way to destroy him. It was September of 1951, and the District Attorney's Office of New York County had spent 3 years and considerable public money building what its senior prosecutors described in private as the most airtight racketeering case in the history of the city. 47 charges, 19 witnesses, a paper trail assembled by a task force of 12 investigators who had followed, for legitimate businesses, and a network of street-level operators so carefully organized that most of them had never once met the man whose name sat at the center of the entire enterprise. The prosecutors believed they had built a cage so precise, so thoroughly documented, that walking Bumpy Johnson into it would be the easiest part of the whole operation. They were wrong about that. They were wrong about almost everything, in fact. But that particular mistake, believing the hard part was already behind them, was the one that would cost them everything. The man who assembled the prosecution's case was an assistant district attorney named Gerald Fitch, 41 years old, educated, with a conviction rate that his supervisors pointed to whenever anyone questioned the department's effectiveness against organized crime. Fitch was not corrupt. That distinction matters, because this is not a story about a good man versus a bad system. It is a story about a man who understood his own system better than the people running it, and used that understanding to expose everything it had spent decades pretending did not exist. Fitch had one weakness, and it was the same weakness that afflicted almost every man in his position in 1951 New York. He believed that Harlem's criminal economy existed in isolation from the rest of the city. He believed the story that powerful men downtown had spent 20 years carefully constructing that organized crime in black neighborhoods was a contained problem, something that could be periodically prosecuted without disturbing the larger machinery of money and influence that actually kept the city running. Bumpy Johnson had known for years that this story was a lie. He had watched how the money moved, where it went when it left Harlem, whose pockets it reached, and whose political careers it quietly sustained. He had never been able to do anything with that knowledge, because knowledge without a platform is just weight a man carries alone. Gerald Fitch, without understanding it for a single moment, was about to give Bumpy Johnson the most valuable platform he had ever been handed. A courtroom, 47 charges, 19 witnesses, and all the time in the world to write things down. The indictment came on a Thursday morning in July. 2 detectives arrived at Bumpy's apartment on Edgecombe Avenue at 6:15, before the neighborhood was awake. Bumpy was dressed and waiting when they knocked. He had been told the night before by a contact inside the precinct that the arrest was coming, and had spent the intervening hours not in flight but in preparation, reviewing documents, making 3 telephone calls, placing envelopes in the care of 3 different people with instructions about when each should be opened. His lawyer, a man named Theodore Cross, who had defended more Harlem cases than any other attorney practicing in Manhattan, arrived at the precinct within 40 minutes of the arrest. Cross was 56 years old, methodical, possessed of a mind that processed legal procedure the way an engineer processes tolerances, with absolute precision and zero patience for imprecision in others. He had kept Bumpy out of serious jeopardy for times in 12 years, through a combination of procedural mastery and an almost supernatural ability to find the single thread in a prosecution's case that, when pulled, caused the entire structure to unravel. When Cross reviewed the indictment that Thursday morning, he sat quietly for a long time before speaking. Then he told Bumpy 2 things. First, the case was genuinely strong, stronger than anything the district attorney's office had assembled against him before. Second, he believed he could still defeat it, but it would require complete cooperation from his client and an absolute moratorium on improvisation. Bumpy listened to both assessments carefully. Then he told Cross something that the attorney would spend the next 14 months trying to fully understand. "Theodore," he said, "I don't need you to win this case. I need you to make sure it goes to trial." Cross stared at him. Every defendant he had ever represented wanted the case dismissed before trial, if at all possible. Trials were expensive, unpredictable, and exhausting. The goal was always to avoid them. "Why," Cross asked, "would you want to go to trial on 47 counts when I may be able to get half of them dropped in pre-trial motions?" "Because," Bumpy said, "the only way to say what needs to be said is in a courtroom. And the only way to be in a courtroom is to let them take me there." Cross did not fully understand this answer in July of 1951. By November of 1952, when the trial finally began, he would understand it completely, though the understanding would arrive approximately 3 days later than it needed to for him to be genuinely useful. The 14 months between the arrest and the trial were not idle months for Bumpy Johnson. From the outside, they appeared to be exactly what the prosecution expected. A defendant meeting with his lawyer, reviewing discovery documents, preparing a defense strategy that would almost certainly fail, given the weight of evidence assembled against him. What was actually happening during those 14 months was something considerably more deliberate. Bumpy spent the first 2 months reading every document the prosecution had produced in discovery, not with his lawyer, not looking for holes in the legal argument, but alone, late at night, reading the way he had always read important things, slowly, completely, looking not for what the documents said, but for what they revealed about the people who had assembled them, who had talked to whom, which detectives had signed which reports, which financial records had been obtained through which warrants, and which judges had signed those warrants. The prosecution had produced a paper trail documenting Bumpy's operations. What they had not understood was that in doing so, they had also produced a paper trail documenting themselves. By October of 1951, Bumpy had a preliminary version of something he had been constructing in his mind for years. A map, not a geographic map, but a map of relationships, of money flows, of the invisible architecture that connected the criminal economy of Harlem to the legitimate economy of the rest of New York in ways that the city's newspapers never printed and its politicians never acknowledged. The prosecution's discovery documents had filled in several gaps in that map that Bumpy had never been able to complete before. A man named Detective Sergeant Lewis Carver had signed 4 of the surveillance reports in the discovery package, and Detective Sergeant Lewis Carver also appeared under a slightly different context, in documents that Bumpy had collected through entirely different channels over the preceding 6 years, documents that told a story about Detective Carver's personal finances that was very difficult to reconcile with a detective sergeant's salary. Similarly, a judge named the Honorable William Marsh had signed 3 of the warrants in the prosecution's discovery package. Judge Marsh also appeared in a set of records that Bumpy had obtained through a contact at a private accounting firm, records suggesting that Judge Marsh's investment portfolio had grown at a rate considerably exceeding what his judicial salary could explain. and that several of those investments had been made through a financial advisor who also happened to represent the interests of 3 downtown real estate developers with documented connections to organized crime. None of this was evidence in the legal sense. None of it could simply be submitted to a court and argued. But a trial is not merely a legal procedure. It is also a performance, conducted before witnesses, recorded in transcripts, reported in newspapers. And Bumpy Johnson had spent 14 months understanding exactly how to turn Gerald Fitch's prosecution into the stage for a performance that Fitch himself would never see coming. The trial of People v. Johnson began on the 4th of November, 1952, in Courtroom 7 of the New York County Supreme Court building on Center Street, before the Honorable Robert Aldrich, a judge who had a reputation for running an efficient courtroom and tolerating very little deviation from procedure. The public gallery was full on the first day, as it always was for high-profile cases, and the press section accommodated 14 reporters, including correspondents from the Times, the Daily News, the Post, and the Amsterdam News, whose readers had a rather different relationship to the proceedings than the readers of the downtown papers. Bumpy Johnson arrived in a dark suit he had chosen with the same care he brought to every professional engagement. Theodore Cross sat to his left, his own legal pad already covered in preliminary notes. To Bumpy's right, at the prosecution's table, Gerald Fitch arranged his materials with the practiced efficiency of a man, preparing for a performance he had given many times before and expected to give again many times afterward. The yellow legal pad appeared on the defense table on the morning of the second day, when testimony began in earnest. Bumpy placed it in front of him, uncapped a sharp pencil, and waited. His lawyer noticed it, but said nothing initially, assuming his client was preparing to take notes on testimony the way any attentive defendant might. The first witness was a financial investigator named Harold Baines, who spent the better part of 3 hours walking the jury through the documentary evidence of what the prosecution characterized as Bumpy's numbers operation. Baines was a competent witness, clear and organized, and the evidence he presented was genuinely damaging in the way that financial evidence usually is. It had the authority of paper, of records, of things that could be held and examined and could not be argued with on their own terms. Bumpy wrote for approximately 40 minutes of Baines's testimony. When Cross leaned over to look at the legal pad, expecting to find questions for cross-examination or observations about inconsistencies in the financial figures, he found something else entirely: a column of names, each name followed by a date, and beside each date, a brief notation in Bumpy's small, precise handwriting. Cross did not recognize all the names immediately, but he recognized enough of them to feel the first small stirring of something that was not quite alarm, but was closely related to it. He leaned close to Bumpy's ear. "What is this?" he said quietly. Bumpy did not look up from the pad. "Later," he said, "pay attention to the witness." The cross-examination of Harold Baines lasted 40 minutes, and Cross conducted it with his usual precision, establishing several inconsistencies in the financial timeline that slightly undermined the prosecution's argument about the scale of Bumpy's operation. It was a competent cross-examination, perhaps a very good one. It changed nothing fundamental about the weight of evidence the prosecution had presented, and during the entire 40 minutes of it, Bumpy wrote nothing. He simply watched. That pattern continued for the first week of the trial. During prosecution examination, Bumpy wrote. During cross-examination, Bumpy watched. His lawyer asked him again on the third evening to explain what he was doing. Bumpy gave him the same answer as before: "Not yet." The second week brought the witnesses that Bumpy had been waiting for, two of them in particular, who took the stand on a Tuesday morning to testify about the surveillance operation that had produced much of the. Carver was a large, florid man in his mid-50s, who had the particular manner of a police officer who had spent so many years being deferred to in courtrooms that the deference had become something he wore on his body, a kind of institutional confidence that expressed itself in the slow deliberateness of his movements. Gerald Fitch walked Carver through the surveillance timeline with practiced efficiency. Carver's testimony was consistent, detailed, and confirmed the factual record of what his team had observed over 18 months of monitoring Bumpy's operations. It was solid testimony, and Fitch knew it was solid, and the slight loosening of tension in his posture during Carver's direct examination was visible to anyone who knew what to look for. During every minute of Carver's direct examination, Bumpy wrote. When Fitch concluded his examination and sat down, Theodore Cross rose for cross-examination. He had prepared, in the usual way, a series of questions designed to challenge the reliability of the surveillance methods and establish gaps in the observational record. They were good questions, professionally conceived. He had reviewed them with Bumpy the previous evening, and Bumpy had listened to all of them and then said, quietly, "Add one more at the end." A single question, which he then told Cross to ask. Cross looked at the question Bumpy had written out and was silent for a moment. "This isn't a question about the surveillance," he said. "It's not really a question about this case at all." "I know," Bumpy said. "The judge will probably allow an objection," Cross said. "Ask it anyway," Bumpy said. "Even if it gets objected to. Ask it so the reporter from the Amsterdam News can hear it." Cross asked his prepared questions in sequence, establishing the gaps and inconsistencies he had identified, scoring the modest points he had anticipated scoring. Then, at the conclusion of the cross-examination, he paused, looked at his legal pad in a way that suggested he was consulting a note, and asked Detective Sergeant Carver a final question. The question was this: "Detective Carver, are you familiar with a financial account held at the First Manhattan Savings Institution in the name of a corporation called Riverside Advisory Services?" Fitch was on his feet immediately with an objection. Relevance. Judge Aldridge sustained it. Cross thanked the witness and sat down, but the question had been asked. It was in the record, and the reporter from the Amsterdam News, whose shorthand was excellent, had written it down completely. That evening, a man Bumpy had never personally met, but had communicated with for several years through intermediaries, an investigative journalist named Samuel Washington, who wrote for the Amsterdam News and 2 other Harlem publications, received a sealed envelope from a messenger. Inside the envelope was a single page of notes in Bumpy's precise handwriting, along with copies of 3 financial documents that Bumpy had obtained through channels that Samuel Washington would later describe in print only as a source with direct knowledge of the matter. The notes explained the connection between Riverside Advisory Services, Detective Sergeant Lewis Carver, and a payment structure that had been operating, according to the documents, for approximately 4 years. They also explained why this connection was relevant to the trial currently underway in Courtroom 7 of the New York County Supreme Court, and why Gerald Fitch's prosecution had, perhaps inadvertently, assembled the precise set of witnesses that would make this information verifiable to anyone, with a legal subpoena and access to the right bank records. Washington spent 3 days verifying what he could, then wrote a story that ran on the front page of the Amsterdam News 6 days after Cross's question to Detective Carver, under a headline that the paper's editor would later say was the most significant front page of his career. It did not name Bumpy Johnson. It named Detective Sergeant Louis Carver. By the time that story ran, the trial had moved to its third week. A second witness Bumpy had been waiting for, a city finance official named Leonard Quast, took the stand to testify about property records and business registrations. He was a minor witness in the prosecution's structure. Cross's cross-examination lasted 11 minutes, and near its end, he asked a question that drew an immediate sustained objection, a question about a different financial institution, a different set of records, and a different name. That evening, a second envelope went to Samuel Washington. Gerald Fitch did not understand what was happening for another 5 days. He was a capable lawyer and an intelligent man, but he was inside the case, looking out, and the shape of what Bumpy was constructing was only visible from the outside, to someone positioned to see the whole of it at once. Fitch's attention during those weeks was directed entirely at the strength of his own case, at managing his witnesses, at preparing for the arguments he expected Cross to make. He was not looking at the yellow legal pad. He was not reading the Amsterdam news. He was not thinking about Detective Carver's financial arrangements or Leonard Quast's connections to downtown interests that had nothing to do with organized crime in Harlem. His supervisor was the district attorney himself. Philip Harrington became aware of the Amsterdam news story about Carver on the morning it ran. He read it twice. Then he called Fitch into his office and asked whether the Carver connection would produce material damaging only to Carver, or whether it connected to anything larger. Fitch said he believed it was isolated to Carver. He said this because he believed it, not because it was true. Harrington nodded, dismissed him, and spent the rest of that morning making telephone calls. By the end of the week, 3 more stories had run in Harlem publications, each one following a different thread from Bumpy's notes. None named Bumpy Johnson. None directly addressed the trial. Each was a story about a different public official, a different financial arrangement, a different piece of the architecture Bumpy had documented through the prosecution's own discovery materials, and each ended with a specific, answerable question pointing journalists toward records that actually existed. Bumpy had not given Washington the answers. He had given him the coordinates. By the 4th week of the trial, the yellow legal pad was on its 3rd page of entries. Bumpy had written 51 names. Beside each name was the evidentiary thread that connected that person to something the prosecution's case had, without intending to, illuminated. Some entries were a single line. A few required half a page of notation. All of them were written in the same small, precise hand that Bumpy had developed over years of conducting business in ways that required absolute precision in record-keeping. Theodore Cross, by this point, had understood enough of what his client was doing to be both deeply impressed and genuinely frightened. He had been a criminal defense attorney for 26 years, and he had seen many strategies, including some creative ones, but he had never seen anything like this. His client was not defending himself. He was conducting an investigation from the defense table, using the prosecution's own witnesses as unwitting sources, and routing the resulting information through a journalism network that was publishing it piece by piece in ways that created a cumulative picture no single story could have conveyed. On the 22nd morning of the trial, Cross arrived to find a note on his legal pad that Bumpy had placed there at some point before he arrived. The note contained 2 instructions. The first told him that he would be receiving, that afternoon, a communication from the district attorney's office regarding the possibility of a plea arrangement. The second told him exactly what terms to accept and what terms to reject. Cross had spent 26 years telling clients what terms to accept in plea negotiations. He stared at that note for a long time. Then he put it in his jacket pocket. It was not from Fitch. who by that point had become a secondary figure in a situation that had grown considerably beyond what he had been assigned to manage. It came from one of Harrington's senior deputies, a careful man named Arthur Webb, who delivered the substance of the communication in language so indirect that it took Cross a full 4 minutes of conversation to understand that what was being proposed was not a standard plea arrangement, but something considerably more unusual. What Harrington's office wanted, communicated through Webb with elaborate indirection, was a resolution to the trial that did not require either a verdict or a dismissal. They wanted something that would end the proceedings without creating a public record of either Bumpy's guilt or the reasons his acquittal had become, in Harrington's assessment, politically untenable. They wanted, in other words, for the trial to disappear. Cross listened to the entire communication without speaking. Then he told Webb he would convey the substance of the conversation to his client. He hung up and sat in his office for 10 minutes. Then he drove to Harlem, where Bumpy was spending the afternoon in the apartment on Edgecombe Avenue that he had returned to every evening throughout the trial, and told him exactly what had been said. Bumpy's response was the same small, controlled expression that Cross had seen on his face in the courtroom every time one of his names came up in testimony. Not satisfaction, precisely, something more considered than satisfaction. The expression of a man confirming that an outcome has arrived that he calculated would arrive, but taking no particular pleasure in having been right, because being right had always been the minimum expectation rather than the prize. "Tell them no," Bumpy said. Cross had prepared an argument and made it thoroughly, the risk of a verdict, the weight of the evidence, the 47 counts. He was honest and not optimistic. Bumpy listened to the whole argument. Then he said, "Tell them no," again. Cross called Arthur Webb and told him no. Webb asked what terms might be acceptable. Cross read from the note Bumpy had left on his legal pad that morning, speaking the words precisely as written. When he finished, Webb was silent for a long moment. "These terms," Webb said finally, "would require involvement at levels above the district attorney's office." "Yes," Cross said. "I expect they would." It was not dismissal of the charges, though that was part of it. What he had asked for, expressed in legal language that his attorney translated into specifics as he read from the note, was a set of institutional changes to how the district attorney's office conducted investigations in Harlem, including mandated disclosure requirements for any financial interests held by officers involved in such investigations, a requirement that Cross was certain would, if implemented, make the kind of arrangement Detective Carver had maintained structurally impossible to sustain. He had also asked for one other thing. He had asked that Samuel Washington be granted a formal interview with the district attorney's office, on the record, regarding the department's investigative practices in minority communities. Not a hostile interview, not a confrontational one, simply a conversation, documented and publishable, in which the questions that had been raised by the Amsterdam News's recent coverage could be addressed officially rather than deflected. It was this second request, Cross would later conclude, that was the most sophisticated element of the entire strategy, because it made the resolution of the criminal case contingent on a journalistic act that, once completed, would exist permanently in the public record regardless of what happened to the criminal case afterward. Bumpy was not asking for promises. He was asking for an action that could not be undone. The negotiations lasted 9 days. During this time, the trial continued, because neither side had filed any motion to pause it, and Judge Aldridge had not been informed that anything was happening outside his courtroom. Fitch continued to present his case. Cross continued to conduct cross-examinations, and Bumpy continued to sit at the defense table with his yellow legal pad and his sharp pencil, writing things down. On the 31st day of the trial, Arthur Webb called Theodore Cross and told him that the terms had been accepted, with two modifications that Cross relayed to Bumpy that evening and that Bumpy considered for approximately 45 seconds before accepting. On the 32nd day of the trial, Gerald Fitch stood before Judge Aldrich and announced that the prosecution was withdrawing 39 of the 47 charges against the defendant, citing insufficient evidence. The remaining 8 charges, he said, were being offered for resolution through a plea arrangement to which the defense had agreed, resulting in a sentence of time served plus a fine. Judge Aldrich looked over his glasses at both attorneys for a moment that lasted longer than judicial moments usually lasted. Then he nodded, and the proceedings that had begun 32 days earlier in Courtroom 7 came to their close. The gallery erupted in the particular way that courtroom galleries erupt when an outcome has arrived that most of the room did not see coming. The reporters in the press section were already moving toward the exits. The 2 reporters from the downtown papers were heading toward Fitch, who stood at his table with the expression of a man who has been asked to announce a result he does not fully understand, and has been given no satisfactory explanation for why that result is what it is. Samuel Washington, the reporter from the Amsterdam News, was heading toward the defense table. He arrived just as Cross was shaking his client's hand. Washington nodded back and wrote something in his own notepad. What he wrote was a headline, fully formed, that he had been composing in his mind for the last 20 minutes. It ran 2 days later on the front page of the Amsterdam News, and it became the lead story for follow-up coverage that continued in various publications for the better part of the next 3 months. The formal interview between Samuel Washington and a representative of the district attorney's office took place 12 days later in a conference room on Center Street. Washington asked his questions from a prepared list. The representative answered in the careful language of institutional communication. The resulting transcript was 40 pages long and contained a factual record of how the district attorney's office had conducted business in Harlem for the preceding decade that had never before been assembled in a single public document. Washington's story ran in 4 installments over 2 weeks, reprinted by 2 other publications, and the 3rd installment was picked up by a wire service and ran in Chicago, Detroit, and Los Angeles. Detective Sergeant Louis Carver retired from the New York City Police Department 6 weeks after the trial concluded. Citing health reasons, he did not give interviews. Leonard Quast resigned from the city finance office 4 months later. Judge William Marsh recused himself from a significant property case 3 months after the trial, citing a conflict he described as having recently become apparent to him, the kind of recusal that people who understood what it meant understood immediately. Philip Harrington served out his term and did not seek re-election. Theodore Cross retired from criminal practice 4 years later and spent the remainder of his career teaching procedure at a law school in upstate New York. He occasionally used, as a teaching example, a trial from the early 1950s that he described as the most instructive professional experience of his life. He never named the defendant. The yellow legal pad was never introduced into evidence. After the trial, it remained in Bumpy's possession, and several people who knew him well reported seeing it on his desk in the years that followed, though he never discussed its contents directly with anyone who put that discussion in writing. What the list contained was not fully known until many years later, when certain documents from that period became accessible. What those documents suggested was that the list had contained 57 names in total by the time the trial concluded, and that of those 57, 41 could be connected through the financial architecture Bumpy had spent years mapping to a single network of interests that reached from street-level operations in Harlem to to the offices of men whose names appeared regularly in the society pages of the major newspapers. It was not a list of criminals, exactly. It was a list of dependencies, of the invisible threads that connected what the city admitted to being and what it actually was. Bumpy never published that list. The people on it knew it existed, because Harrington's office would have told the ones who needed to know. The existence of the list, known but unpublished, was in many ways more useful than any publication could have been. It was a permanent condition rather than a single event, impossible to refute because it never appeared in any form that could be formally addressed. The institutional reforms that Bumpy had negotiated as a condition of the trial's resolution were implemented over the following 18 months with the particular enthusiasm of men who understand that the alternative to implementing them is worse than the reforms themselves. The disclosure requirements for officers involved in Harlem investigations were modest in their language and significant in their practical effect, because they made the kind of arrangement Carver had maintained visible to anyone who looked for it, which was all that was required to make it untenable. Harlem in the years following the trial was not transformed overnight. What changed was something harder to measure, and therefore harder to dismiss, a shift in the understood terms of the relationship between Harlem and the institutions that governed it, a recognition on the part of those institutions that certain arrangements that had been taken for granted were no longer safely invisible, that there was, now, someone keeping a list. Bumpy Johnson was never again indicted on racketeering charges. This was not because his operations became less visible or because law enforcement stopped watching him. It was in the assessment of people who understood how these calculations were made, because the cost-benefit analysis of bringing another prosecution had shifted in ways that were difficult to explain in public but perfectly clear to everyone involved in the private calculation. Prosecuting Bumpy Johnson had turned out to be considerably more expensive than anticipated. The currency of that expense had not been money, it had been exposure, and exposure, once demonstrated as a consequence of prosecution, functions as a very effective deterrent to future prosecution. The yellow legal pad sat on the desk in Bumpy's apartment on Edgecombe Avenue for a long time after the trial. Visitors who noticed it generally assumed it was a working document, something currently in use, because it sat in the center of the desk rather than filed away, as if its work was not finished. Perhaps it was not. It was a document that had never been used as evidence and had therefore never been neutralized the way evidence is neutralized, processed, filed, made inert by the machinery of legal procedure. Some things are most powerful when they remain potential. The men who needed to understand what was on that legal pad understood it without ever reading it. In a courtroom, a defendant who takes notes is understood to be preparing a defense. Nobody in courtroom 7 during those 32 days understood that the man with the yellow legal pad was not defending himself at all. He was building something, slowly, precisely, name by name, in the small, careful handwriting of a man who had learned long ago that the most permanent record is the one nobody thinks to look for until it has already done everything it was ever going to do. Ellsworth Bumpy Johnson walked out of that courthouse on a cold November morning, adjusted his hat against the wind, and took a car back to Harlem. He did not speak to the waiting reporters. He went to the apartment on Edgecombe Avenue, placed the yellow legal pad in the center of his desk, and made a single telephone call. The person on the other end picked up on the second ring. Bumpy said 4 words. Then he hung up. But Samuel Washington, who spent the next 3 months writing the most important journalism of his career, told a colleague years later that he believed he knew. He believed that Bumpy Johnson called to say, simply, that the list was finished. Not that the work was done. That was never the claim Bumpy made about anything. Just that this particular list, on this particular yellow legal pad, had reached its conclusion. What came next was someone else's job. He had only ever promised to write it down.